Hello, everybody, and welcome to this Monday edition of Macro Pro and Friends. I'm joined by my friend, James Rossi. How are you, James?
I'm doing very well. How are you?
I am doing really well. It's the end of summer, and I'm just dying to find out what everybody is doing or what they did for the summer. So I'm going to ask you the question, and then you can tell us your answer. But I want all of our attendees to type it in. So now that we're into summer, what did you do this summer that was fun and a little different? So everybody out there, please let me know because I can't wait to see your responses. And James, why don't you tell us what you did?
I did a few things. I'd say the most notable is I recently got back from a 4-day catamaran trip where it was eight of us, 4 couples, and one of my close friends is a captain, so he captained the catamaran. We each had our own bed bath, and we went across to Catalina, stayed in Avalon for a few days, hit 2 harbors, and did a lot of swimming and paddle boarding and kayaks, and we had a little dinghy, and it was just, honestly, it was one of the coolest things I've ever done.
Oh, wow, that is awesome. Well, I can't wait to see people's responses. Let me see here. We've had some. So they did a day trip to Reno. They went to somebody went to Vegas, family vacation to Great Wolf Lodge. I hear that's a really cool place. I've never been there, but I hear that's really cool. Poor Steven, he said he worked too much. I hate that. Gina went on a road trip. Hawaii. Somebody went to Hawaii.
Hawaii is
Wendy,
always good.
Wendy, I did see those pictures on Facebook. She went to the Mediterranean. People went
Oof.
camping. Oh no. Shirley says that she just worked. So keep the answers going. I bought a lake house, and so we're here. And guess what happened to me in my lake house? August is the coldest August in history in Washington State. So I did not get to use it very much, unfortunately, but that's kind of a sad story, right? Sad for me, but I'm sure eventually I'll get back in the water. But that was really fun. Okay, everybody, please put those in because I'm going to look at those still, but I'm going to do a little bit of housekeeping and then James is going to take this over. So today you are going to get 1 CEU. You should receive that CEU credit within 1 hour. Remember, I can only help you for 30 days. So if you have an issue, you need to let me know very, very quickly. You must be logged on to the GoToWebinar platform, and you cannot be sharing somebody else's link because the certificate is going to be in their name for that. We do have a handout that Jane's put together, a really nice handout. You can download it here from the control console. If you have any questions, I don't think we're going to have time. It looks like it's going to take a while, but if you have questions, put it in the question box, same place you told us about your vacation plans, and I'll make sure James gets it. And James has said that he will be happy to reply back to you on that. And then lastly, you can watch this on the Macro Pro YouTube channel where all of our great programming is. So James, it's now 100% all you.
All right, well, thank you. And before you take off, you can see the slides, right?
Yes, sir. Everything is perfect.
All right, excellent. All right, so welcome everybody. It's wonderful to be here for y'all. It's always an impressive attendance for these seminars. Everyone is really into this. I know a number of the people in here, some excellent adjusters in here. And frankly, if you're taking your time out of your day at 1:30 p.m. on a Monday, you're pretty serious about what you do. So thank you all for being here, and I'm going to hopefully give you some information that is useful to you so that we make use of your time. We're going to be talking about discovery, a few other things, but the first thing we're going to dig into is the duty to investigate. This is something that I feel is lost on adjusters and attorneys alike. Sometimes we just get so into defending the claim that we really forget about what our duties are in terms of investigating in good faith and things of that nature. And so I just want to start off by pointing out how important it is to do a reasonable and timely investigation once you have notice of an injury or a claim. It's quite critical. And you have to go for all information that could help you determine whether benefits are due. It's not just looking at one specific benefit. For example, you may have an issue for medical treatment, but based on your experience, you know that that's actually going to be a possible TTD and PD exposure, et cetera. You can't limit it just to the one area it's being claimed. You need to do a thorough, thoughtful, and full investigation to make sure that all benefits that could be owed are provided. So if you receive new information after doing an earlier discussion or investigation, you still have to look at that new information and reevaluate your defense. So if you have a defense, an AOE COE defense, and you're saying, you know, we're maintaining our denial, and then all of a sudden some new information comes in for which you should overturn your denial, then you have a duty to do that. And the most common situation where that applies would be, for example, when you've got a denial of no substantial medical evidence or evidence showing an injury, and then later you get a QME or you get some other evidence, or a witness comes forward and you get some other evidence that suggests the denial needs to be overturned. So you have a duty to constantly, throughout the pendency of the claim, to do this. One thing I see here and there is there will be a claim that they don't need to do the work because they've issued an objection. Well, you still have to have a good faith objection. Sometimes objections are sufficient to get you out of doing something, but you can't just object and say that's the basis for why I'm not doing it or why I'm not providing a benefit. You also can't rely on the burden of proof to excuse investigation. Just because it's the applicant's burden to prove an injury, it doesn't mean that you don't have to investigate to determine whether the benefits are actually owed. So make sure you're constantly doing the investigation and you're doing it in good faith. And it doesn't matter whether it excuses or it requires payment. You need to investigate. Some of the pitfalls can be avoided if you document your investigation thoroughly. Basically what happens is when you are creating claim notes, that's your Bible. And if you're ever audited, they're going to look at all of your claim notes and the documentation to see how you handled that file and whether you handled it in good faith. And so if you don't document all investigation that you've done, even if you did good stuff that wasn't documented, when you get in for that audit review, they won't know, and it could put you in a difficult position to where you are unable to properly show good faith and proper investigation. And another tip I can give also is document where the claimants frustrate the investigation. If the applicant is refusing to give you information that you need to assess the claim, refuses to give a statement, refuses to do the things that you need done, whatever it is that your particular case needs, document that. When you get audited at some point, they'll see that you were trying to get this information, that it was the applicant that was frustrating the investigation, and so therefore you'll have good claim notes to support your position. And that's really what it comes down to, is get it in the claim notes. There's a supervisor in Fresno that he always said, if it's not in the file, it doesn't exist. And it's something that I've always taken to heart, and I think he's 100% right. And so it's a term that I would repeatedly think about. Make sure it's in your file. If it's not, it doesn't exist when the auditor comes. Now, just because you are delaying a claim, please note you still have to pay up to $10,000 in medical treatment, and it's subject to the MPN and UR, so you do have the right to enforce those during the delay period. But even if you reject the claim, ultimately you could have liability up to $10,000 for treatment prior to the rejection of the claim. And if you need to, you can file DORs on medical issues during the delay stage. This here is a fantastic diagram. It was prepared by attorney Randy Pollock. He's, in my opinion, one of the best in the state when it comes to workers' comp defense attorneys. And this little flow chart, or just a diagram, whatever you want to call it, it has a lot of information that you look at so that when you're doing your investigation, you think about these things. And it's not necessarily complete, but it is quite outstanding. And if you guys, you want to save a copy of this particular slide, you can take a look. We're not going to go through it all today. But if you look at just the first line, it's the history of the injury from the employee. You're looking at the history from the employer. What did he tell the doctors? What do the witnesses say? All the different types of documentation where you can get a story that, and you can compare it and you can see, does it make sense? Is the applicant being truthful? And if you've got 4 different variations of how something happened, well, that's a huge red flag. But anyways, this is a nice little chart for you. So go ahead, and he gave me authority to use this. Next, we're going to touch on it, penalties and sanctions. The main 2 sections for penalties and sanctions are 5814 and 5813 of the Labor Code. 5814 could subject you to a 25% up to $10,000 penalty on a case if you unreasonably delay or refuse to pay compensation. So it's something that you constantly want to make sure that you're doing everything you're supposed to do. You're not ignoring the file. You're properly evaluating things. Document your file that you're doing these things, and show good faith so that you can avoid ever having to pay this penalty, which can get big. Up to $10,000. It doesn't take a whole lot to get to $10,000. Then there's another labor code section, 5813. That's the code section that pertains to sanctions. And so in that instance, if we take a unmeritorious and frivolous position, then we could be sanctioned, and it could include attorney's fees, which can get racked up. They can go really quick. If they say they had to prepare for a hearing, go to a hearing, then they go and have to deal with a petition for removal or recon or anything like that, they can get attorney's fees that can rack up really, really quick, especially in today's times where they're getting close to $500 an hour at most boards. And then they can also sanction for $2,500 as well. And from an attorney perspective, this is a scary one, because if we were acting in bad faith and we got hit with a $2,500 sanction, we would have to report that to the bar. We have to report anything over 1,000, or maybe it's 1,000 and up. So that's the last thing we want to do, is have to deal with that kind of stuff. So keep in mind, good faith will protect you from these types of things. As long as you're operating good faith, you should be good. There's also audit penalties. So for example, when you deny a case, and we've talked about defenses in the past, but when you deny a case, you want to have all your defenses that you have in your denial. Because if you issue a denial without stating a lawful, factual, medical, or legal basis, then you can actually be penalized, and that's up to $5,000 for that. So you want to and be safe. Include your defenses, because then no one can ever say, well, you didn't do a proper denial when you indicated post-term and prejudicial failure to report, lack of substantial medical evidence, things like that. Period. Now, we'll talk a little bit later about the presumption of compensability, and just know that failure to indicate a lawful, factual, medical, legal basis for the denial does not mean that the presumption applies. But even though the presumption doesn't apply because you timely denied it, you still got to deal with this potential for penalties. And there's another one for $5,000 for failing to investigate a claim. So as I was saying earlier, you need to investigate your claims. And then and the 3 types of classes for the benefits that there's usually penalties is TD, PD, and vocational rehab. There's other areas where you can get hit for penalties as well. And frankly, we're not listing every possible penalty in this presentation, but just more so that you're aware of them. But not paying medical treatment timely can get an increase of 15%. And then one that we all deal with, we've all seen it, is a strict liability increase of 10% when benefits are not paid. And this doesn't require negligence. It doesn't require anything like that. It requires that it wasn't timely paid when it should have been. And as you can see, unlike 5814, it applies to reasonable delays in payment. strict liability. All right, so now we're going to talk about discovery. So you've got a case, an injury comes in, and you want to know what you can do to defend the case. And so we're going to talk about some of the types of discovery. Now, one of the first ones is going to be an AOE COE investigation. And that's where an investigator goes to the job site and wherever else he needs to go, frankly, where the injury happened, uh, or just to meet with employees who were witnesses, things like that. And they'll piece everything together and they'll figure out, did an injury happen? Uh, what do the witnesses say? What does the employer say? Hopefully they'll get a copy of the employment file. And if it's a job site where the accident happened, they can evaluate subrogation. They can evaluate whether the story makes sense. Basically look at all the defenses. So a good investigator will look at all of the defenses. Now, hopefully you got an employer who helps you guide and direct you to the correct defenses, and the AOE COE investigator can target that. But if you got a good one, they know the general defenses, and they're looking into all of that. So they'll ask and find out whether the applicant, reported the injury, who witnessed it, was medical treatment provided, was a claim form provided, do they support or contradict the claim, the witnesses, and once you have all of that, and they'll also look at other things too, like medical history, what's the personal life of the applicant. They could look at social media, which we'll talk about in a little bit. The investigator can ask questions and gather as much information as possible. And sometimes you get very little, sometimes you get a lot. So it's very important. But I do want to caution you on one thing is one time I had a case, and it was a quadriplegic case with an AOE COE issue. And the AOE COE investigation report indicated that answered the question in a way that supported the defense. And it was the question of really the number one question asked by the investigator. And so since it was such a huge case, I'll typically listen to the statements because I like to make sure that they actually say what is indicated in the report. And so I went and I listened to this particular statement, and the report was exactly the opposite of what it was. So instead of having a fact that was perfect for me, I had a fact that was the opposite of that. It was a bad fact. So then I had to go and meet with the employee and see what was going on and take it from there. So the point being is, just because a report says one thing doesn't mean that it's actually the case. And if you have a big enough case, it's worthwhile to go and listen to those statements, particularly the key ones. All right, so the next thing we look at is other claims. It's one of the big areas where we defend workers' comp claims, as we look for prior claims, subsequent claims, prior complaints, injury, things of that nature. And any of those that we can get, we can use to test the applicant's credibility in a deposition, things of that nature. So one of them is an EAMS informal case search. I use this all the time. I'm in it quite often. And I've given you the link. If for anybody who doesn't know, I'm sure some of you use this yourselves. But if you click on that link or type it in, I don't know if it's clickable, you will be taken to the website for EAMS. And then you can type in information such as the EAMS case number, the injured worker's first name, last name, date of birth, the worker city, and the zip, and you can search for other claims filed by the applicant. And usually they'll be linked to your claim, but not always. Sometimes they're completely unlinked. But it's a great tool, and sometimes you'll get 25 names or 100 names, so it's hard to do, but you can weed it down by trying date of birth, which I usually don't immediately do date of birth, but because, like I said before, sometimes they're not connected. Sometimes someone's used multiple dates of birth, and so I don't want to limit it to just that date of birth. But it's a fantastic tool. It also can give you updates on your case. You can also look at, if you look where it says case search, to the right of that, it says lien search. The lien search allows you to see what liens have been on, are filed, and the amounts, the parties. So it's a wonderful website. The next tool we use is an edex. And that's not something that we do on our end. That's something our copy service usually does. So MacroPro will provide us with an edex that shows a formal list of all claims filed by that particular applicant. And they base it off Social Security number. So if there's multiple Social Security numbers, you'll want to do multiple searches. But the edex is a more formal version of EAMS, the informal case search. So we do that as well. We do both. And then last but not least, by any means, is the ISO claim search, which is a database that the adjusters, the TPA, has access to. I don't have access to it. The attorney does not, but the TPA does, and it has everything, every claim that this person is tied to, whether as a plaintiff, defendant, claimant, property damage, you name it, it's going to come up in that search, and it gives us a lot of ammunition to find claims, particularly non-work comp claims, because we'll usually find a non-work comp claim in an edex search, but even on EAMS informal case search. But the ISO returns car accidents and things like that, which are not in that database. Only WCAB files are in the edex database. So it's a number. To me, it's the first thing I like to know is any prior claims on that ISO. And another thing on those ISOs that you should know is, say you run one in 2 weeks after the injury, and the case has been going on for another year and a half, and there's some malingering. It just seems like there's some exaggeration. You can run another ISO and see if there's been anything that's happened since. Or say you get new information such as another social, another date of birth, another address. You can plug those in to see if anything comes up, and then it'll be a thorough evaluation. So just because you do it once doesn't mean you don't do it again, because I've seen it a number of times, not often, but a number of times where a claim was made after hours because there was a subsequent car accident or something of that nature. The next tool, it's a great tool, is a medical canvas. I've had some big success with medical canvases. Give you an example. I had one where the case was admitted, paid out $200,000 on the case, came to me, and it just wasn't making sense. And so the injury had happened up in Northern California. The applicant was from Southern California. And so we decided to do a medical canvas in the area of where the applicant was doing the job. And sure enough, we found a medical record indicating he had been in a car accident the day before, and it was his fault. So essentially what it looked like he was doing was, and he denied prior car accidents in his deposition, essentially what he was doing was trying to pin that accident onto our employer, claiming it was from a fall. And so the medical canvas was very successful at doing that. And just because you have, in other words, the point being is you may have someone from Los Angeles, but if you have other areas where they lived, you can do another medical canvas in that area, and you can get leads. And one of the big leads can actually be something that I used to not even give much value to, and that is pharmacies. But now when I do a medical canvas and I see pharmacies, I'm very interested in that, because those are usually going to have prescriptions, doctors who prescribed it, and all of a sudden you're going to get leads as to who the applicant has treated with in the past. So it becomes very helpful. So don't ignore pharmacies. Another thing you can also do is actually subpoena whatever pharmacy the applicant uses in your case, because there's a good chance that they were using that pharmacy before the injury as well. And so it can help there. Another area, and this isn't for necessarily medical canvas, but sometimes you don't get anything. You've got someone who maybe is illegal or just has not. Are we having a technical issue. I think we're good. Has not conveyed, where they've treated, things of that nature. And so I'll issue a subpoena to a clinic. This happens a lot in the Central Valley, where you've got farm workers or you've got day laborers, things like that, where they end up making a claim and they don't tell you about any treatment, but they are here for part of the year. And oftentimes, I can't tell you how many times it's been, but it's been quite a few. Uh, I'll subpoena, like for example, a clinic called Clinica Sierra Vista. Oftentimes, they actually will get records from these, and there have been several cases won because of these types of records, where it's just kind of a cold subpoena. We don't really have any leads, but it's near, within 30 minutes of the applicant's place of residence. And so ultimately, we subpoena those records and find out that they were already having those issues. And you would never have gotten them if you just relied on what the applicant said, because the applicant didn't disclose that information. So medical canvases are fantastic, even though that last instance it wasn't found in a medical canvas. Social media and background checks. These are very, very good tools. Not as good as some of the other things that I've mentioned, but they're typically not real expensive and pretty easy to do. Just medical canvases are not very expensive either, by the way, just so you know. I would do them in pretty much every case that becomes litigated, at least in the area of where the applicant lives. But social media and background checks are similar. Background check, you can find criminal history, other names, residences, and those residences could then go to a medical canvas so that you get the good stuff. And then, or traffic violations, motor vehicle accidents, things like that. And then social media is crazy to me, because I'm just blown away at how many people will be open about their life, and no restrictions as to who can view it, and they'll post anything and everything, even if it's completely inconsistent with their work comp claim. And I've seen it many times. I had a case, for example, where this woman, she was aspiring to be an actress, was a professional dancer, and she had a COVID claim back in the day when COVID was newer, and it was at a scary time, frankly. And then she also had a foot injury. And so we dug around on social media, and she had an open profile, and in it she was doing dances and reenactments and all kinds of videos that were completely inconsistent with her testimony. And she was alleging to have a very, very bad case of COVID, and she was claiming that she couldn't walk on the use her right ankle. I think it was a right ankle, and so she couldn't walk well, and just a lot of problems. Couldn't dance anymore. And then yet here we had this social media video showing her doing all of those things without any limitation. And then on top of that, we dug a little bit deeper and found she had a YouTube page, and she had done her and a friend of hers, because they were new, COVID was new, her and her friend were interviewed on a show regarding their symptoms and all of that kind of stuff. And in that, she gave all kinds of inconsistent information with our case. And so we ultimately were able to dispose of the case using this social media information. And it was pretty stunning, to be honest. And then, there's been many others. Another one was one of the nastiest cases I had for years. And this guy would go to the doctor emergency room every 2 weeks, 4 weeks, said he needed back surgery, he needed neck surgery, he needed all these things. And it was just an extremely difficult applicant, one of the most difficult that I've seen. And ultimately, when we got into his social media, we had him doing all kinds of things he said he couldn't do. And so because of that, we were able to finally get the case resolved, which was not easy, to say the least. But that social media is what did it for us. Took the deposition, got inconsistent statements, and then once you get that, you're in good shape. Big fan of social media checks. Oh, and just before we continue on that, what I like to do, I like to look at social media, as to what's publicly available. But at the end of the day, I like my investigator to be the one that locks all the information, that they save all the information, so that if I ever need to go to trial, they can authenticate everything. Because if it's me doing it, I would be the witness, and I don't want that. So that's something to consider. Have your investigator, your investigation company, lock it all down, save it, secure it, so that way it doesn't go anywhere. Because oftentimes people will delete this stuff. Subpoenaed records, huge tool, great tool, obviously. We're typically looking for prior injuries, overlapping injuries, prior conditions, not necessarily an injury, maybe just a condition, a prior pain, whatever it is, anything that allows us to evaluate credibility of the applicant, determine apportionment, determine causation in general. Subpoenaed records are fantastic tool for that. So some of the main things that we'll subpoena will be the WCAB files. It'll be personal medical records, claim files related to the ISO, car accidents, prior claims, subsequent claims. Then there's treating physicians we may want to subpoena, whether they be in our case or from a medical canvas. Other employers can help us do, potentially find background information that can lead to helpful information, and or criminal records. And these are all just some of the targets that you want to look for. And subpoenas will allow you to get that. So one tip I want to give you, though, that we do is when we get a claim, that one of the first things we do is look for prior injuries, prior complaints and treaters and things of that nature. When we find out that there's prior work injuries and claims, and you got all the lien claimants listed, so you know who to subpoena, and then say you got a civil case as well where they were in a car accident. Typically, the only records we'll subpoena are going to be the WCAB case files. And the reason for that is those are public record. Those are something that we can get. We don't have to give notice to the other side. We don't have to do anything. We just get a copy of the records. And we'll want that before the deposition so that we can see what's in it if possible. If not, we still can ask the questions and then get them. It's not, we know what to ask. It's pretty much the same questions. You thoroughly ask it. In fact, a little bit later, I'm going to give you an example of that in a short video. And so we're going to want to go through all of those questions and see if, in fact, they have any impeachment evidence. And ultimately, if it's determined that there's evidence that we can use in those, we'll ask it in the deposition. And after the deposition, we'll subpoena all the records that we believe are pertinent. And at that point, the other side has notice. And the reason why I'm saying this is because earlier in my career, I would just subpoena everything. And when you subpoena the records, the other side gets a copy. And so what would happen is the applicant attorney would have these subpoenaed records in their file when they prepare for the deposition with the applicant, and they could prepare a story. Well, I want the deposition to be a lie detector test. And so I don't want them knowing that this exists. I want to see what the applicant would say without him knowing we know already, because that's the only way you really test credibility. So what we'll do is we'll get the WCAB files, then we'll follow the rest of the leads where the other side gets notice so that we can get a true test of credibility in the deposition of the applicant. Surveillance. Surveillance is, I love it. I mean, I just absolutely love surveillance. If you use it right, it is a dagger. The key is to use it right, because I've seen it used incorrectly a number of times. To me, I never want to give surveillance up to the other side until I've had a chance to depose the applicant, because unless you got something like, someone's confined to a wheelchair and you get surveillance of them walking, you don't need a deposition. You're set. But that's not the case most of the time. Most of the time, surveillance can be explained away if they know. And it could be I was on medications and I had good days and bad days, whatever it is. There's stories that can usually get around the video if they're coached properly. And I don't want that. So I take a deposition and thoroughly investigate the surveillance results to see whether it makes sense. And surveillance, it's good for impeaching the applicant. It can also tell you whether you've got a legitimate injury. I mean, that's, as we were talking earlier, it's not just how do you deny claims, how do you deny benefits, it's does it support having to pay them? And if you've got someone on video and it shows, well, yeah, this guy really is injured, and look, he's using a cane, he just clearly looks injured. Well, you know that you're likely dealing with a credible applicant and a real injury. So it's got value both ways. But it can also impact permanent disability ratings. The doctor will say, well, you could do a lot more than you told me, and I based your PD rating on what you told me, and so therefore I'm reducing the rating. It could be they're no longer showing that they were TTD as claimed, especially if you catch them doing other employment and lying about it. But it's a great way to catch fraud. To me, it's just it's a wonderful. If there's a questionable claim, it's a wonderful tool when coupled with a deposition. And so now we're in depositions. As I said earlier, I look at a deposition as a lie detector test. I want to go into that deposition with the applicant knowing nothing that I know, and I want to ask the questions so that I can see if the applicant's going to be honest and forthcoming. And if they are, great, then you got an honest applicant. It makes you feel better about life when someone's truthful and not malingering and not exaggerating. Of course, what happens quite often is to the contrary, where they claim they can't do A, B, and C when they really can, or they exaggerate, things like that. So I want to set it up, the deposition. Always have a plan going into a deposition. This is what I tell all my attorneys, that you go in with a plan to where you're going to be able to ask the questions in a way that the other side has no idea where you're going. And so it could be something as simple as a checklist. You ask it in a checklist, and in the middle of that checklist is the doozy. And I've got a video. I'm going to show you a few examples coming up here shortly. But it's definitely, if used correctly, it's a lie detector test. With respect to the employer attendance, I'm a fan of the employer attending depositions in most situations. I'm not a fan of it if I have surveillance or I have some kind of significant impeaching evidence. Then I'm not a fan, because I just want to test the credibility, and I don't want applicant to be nervous about the employer. I literally just want to use the deposition to see, as a lie detector test, to see what I get. These are some of the important topics normally covered. Obviously, medical history, prior injuries and complaints, treatment, questions to prove the elements of a defense. You got to know what your elements are of that defense so that you can ask the right questions. Otherwise, you miss one element, you don't have a defense. Benefits due that are due, eliminate add-on body parts. Sometimes they'll have a claim for 4 body parts, and you get the application and it's got 9 body parts. Oftentimes, the extra body parts were because of a overzealous applicant attorney, and the applicant will say, stick to the 4. So you can eliminate body parts that way. Evaluation of impeachment evidence, that and prior injuries, those are the 2 biggest ones to me. Well, I guess proving your elements too is critical. And then general background information, which that can help you for medical canvases and the like. So here we've got, I'm gonna play a few videos for you. This first video is going to be based on a case. These are based on real cases. This first one is based on a case where the applicant had a prior injury found on the ISO, and so we were going to try and see if if the applicant was credible, and we were told that there was a deposition taken by, we were subbing in, that there was a deposition taken by a prior attorney, and they were saying that the applicant denied the prior injury, and they were really excited about the defense in that respect. And so when I went and looked at the deposition transcript, it had double negatives in it. And so essentially, because of those double negatives, the testimony had no value. And so I'm gonna show you a couple examples of deposition testimony right here. And anybody, the witness in this, anybody who sends a message to Diane indicating the name of this gentleman, I'll give you a hint, he is an actor, but anyone who gives me the correct name, I'm going to send you something in the mail.
James, we cannot hear.
You can't hear it?
No.
Oh, well, let's see what's going on there. Try this.
Still cannot.
Have you ever been injured in a car accident? No. Have you ever been injured in any kind of motor vehicle accident? All right, were you able to hear that?
No, not really.
Oh, not really, huh? Okay, let me see.
You'll need external speakers next time.
Okay. Well, that's a bummer. Let me see if I can get this. Give me one.
That's what I love about you, James. You are determined to make it work.
Well, this is a bummer. I really wanted to play these for you. So this is what a deposition looks like, by the way, and on Zoom these days. It's so easy for an employer to attend. And that's one of the reasons why I think it, and frankly, even adjusters can attend to these things. They sit at their desk and they can have it in the background if they're interested. And I've actually had that happen here and there, where the adjuster will, in fact, listen to the testimony. But I'm going to try one more thing here. Sir, have you ever had any injuries?
No.
Hey, do you have your
slip and
phone?
fall injury?
Okay.
No. Have you ever been injured in a bicycle accident? No.
Have you ever been injured in a motorcycle accident?
No.
Have you ever been injured in a car accident?
No.
Have you ever been injured in any kind of motor vehicle accident as a driver, passenger, or pedestrian?
No.
Was that better?
It was at the beginning, but then it kind of faded out.
All right. Well, darn it, because these are good things.
Do you have a phone you can call in?
Yeah, maybe.
Let's see here. I'll look for the call-in number.
Yeah.
Actually, I don't know how you would call in.
Wait, maybe this will help. All right, I think I got it figured out. Yeah, let's try this.
And everybody
Sorry
turn
about
your
this,
speakers
everybody.
on loud. Everybody turn your speakers on loud.
Sir, have you ever had any sporting injuries? No. Have you ever had a slip and fall injury? No. Have you ever been injured in a bicycle accident?
James is not working.
Have you ever been injured in
motorcycle accident? No. Have you ever been injured in a car accident? No. Have you ever been injured in any kind of motor vehicle accident as a driver, passenger, or pedestrian? No.
All right, so you could hear that, right?
Barely, but yes, we heard it.
Okay, so basically what I did in that deposition is set up, so we knew we had a prior car accident. So what we do is we put it into a checklist format. And that's why it's, have you ever, I mean, we put motorcycle, bicycle, we put those things in front of car accident because it sounds like a checklist. And so by having that checklist format, they don't think anything of it. They don't think, well, he knows about my car accident. It's a way for us to disguise where we're going. And that's an example of what I was talking about earlier, where we use depositions in a way so that they don't know exactly what it was we were trying to do. All right, so here's a case example. 35-year-old laborer alleging a injury to the right knee, 2 prior claims, and the deposition was set to investigate the applicant's credibility, including the prior injuries.
Sir, prior to your January 1st, 2024 date of injury, you never had any injury at all involving your left knee?
No.
Prior to your January 1st, 2024 date of injury, you never had any symptoms in your left knee of any kind?
No.
All right, so that in that clip, the video, the questions were very poor. Those are just like the example I gave you, and this is actually from that case where there was double negatives. You never had any prior complaints. Well, how do you answer that? If I say yes, what does that mean? If I say no, what does that mean? So if you're ever in a deposition and you see your attorney asking with double negatives, just know they got nothing and you should point it out to correct it. Now I'm going to show you the next clip is going to show you how it should have been. And you'll see that she asks a very thorough questions. She goes deep to ask it all the different ways so that we can say, well, you say that it was an error when you answered that question, but what about when you answered it here, 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 and here?
Prior to your January 1st, 2024 date of injury, have you ever had any injuries involving your left knee?
No.
Prior to your January 1st, 2024 date of injury, had you ever had any pain in your left knee?
No.
Prior to your January 1st, 2024 date of injury, had you ever complained to a doctor or medical provider of any pain or problems involving your left knee?
No.
So the first time in your entire life you ever had any symptoms in your left knee was after your injury on January 1st, 2024?
Yes.
Were you able to hear that?
Yes, we could hear that. It was much better.
Perfect. Okay,
Lizzie?
so go ahead.
Lizzie's got a booming voice.
Okay, good. Yeah, and I've been told that I have like a voice that's hard to hear if you have bad hearing. I guess I talk softly, but anyway, so you'll see what she did is she asked all the different ways of prior complaints, prior problems, prior pain, prior treatment. So this is the first time you ever had pain in your life was after this injury. She's got them locked. There's no way they can get around it, and there's no double negatives. So it was done the way it needs to be done. That's how we do it. All right, and this is the last case example. This was based on a real case, and we're talking about a 34-year-old painter who injured his right shoulder. The very next day he had surgery on that shoulder, was TTD ever since, and that date is wrong in terms of this surgery. That should have said 2024, but he TTD ever since, got an abnormal MRI of the right shoulder with constant complaints. Social media search showed applicant had a lake house and owned a boat, so surveillance was assigned due to potential lingering. So I'm going to show you some surveillance, and then I'm going to show you a clip as to how we would address that surveillance. Except for the video's not here. You can't see it, right? I can't see it.
No, it's not on.
All right, so let me tell you what it was. It's surveillance video of this gentleman here. He's on a boat. He's doing all kinds of things above his head. He's he's got the bimini, which is the cover, and he's got his arms up doing it, hitting things. Yet supposedly, he's got a really messed up shoulder, and he can't do anything. And so the surveillance was extremely, extremely powerful. And let's see how you would address that in a deposition.
Sir, you're claiming a right shoulder injury that occurred on June 1st, 2023. Is that true?
Yes.
And you had right shoulder surgery the following day on June 2nd, 2023. True?
True.
Since that injury, what can't you do now that you could before the injury?
I could lift my hand over my shoulder. I could just do daily activities.
So if you were in class and you wanted the teacher to call on you, since your injury, has there been a time where you could raise your hand above your head so that the teacher could call on you?
No.
Is that because of your injury?
Yes.
Has there been a time at any point since the injury where you could raise your right hand above your head?
No.
What if you took medications? Do the medications allow you to use the right hand above your head?
No.
What about when you had the injections to the shoulder? Were you able to temporarily move your right hand above your head?
No.
So since the injury, is it fair to say you have been unable to put your right hand over your head even one time?
I have not been able to.
And that's because of the injury?
Yes.
And is that the reason you're not working?
Yes.
And you're a painter, which requires you to raise your hand above your head to reach spots that are above you, true?
True.
Has there been any point since the injury where you feel you could do that?
No.
So as you can see, it's so many questions are asked. So you go into the deposition with a plan. All right, I've got a guy who's got his hands above his head. He's doing the bimini. How am I going to get there? And I want him to know that I know, because if I ask anything about, can you use your boat, you go boating, hobbies, things like that, that's the last thing I want to do, because then it could make them suspicious that I know about boating. And so one thing I wouldn't need to do it in this particular case because he's a painter, which means he's already doing above his head work. But let's say he wasn't a painter, he was someone else doing some other type of job. The way I would do it is similar to what I just did in there, raising your hand in class. Do you have any problems with doing that? I'm going to ask things that are just totally irrelevant. So that way I can get the questions answered in a way that they don't know where I'm going, that they don't know that I know what I know. And so this is an example of how that's done. And then we got to ask, is it because of the injury, the medications, did that change it? And we asked about the injections, all those kinds of things. And frankly, there's more questions that would be asked as well, but this is just a sample so that you have an idea of what it is that I'm referring to. Other targets to depose, these could be your PMKs. I do PMKs quite often, actually. If I don't know who to subpoena and it's something important, I could do, like I recently did one, a PMK for blood work and tests at Cedars, because I needed to know whether something existed that we thought may have existed. But it can be on many different areas. It could be employers, and wages, whatever it is. but they're great tools when you don't know who the actual person is. Then there's also medical providers, obviously, and sometimes OSHA. I had a case where the OSHA records were what did it for us, and so fortunately deposing a key OSHA person was very successful. Sometimes the police and paramedics are important, depending on the type of injury it is and the type of accident. So now we're going to just quickly talk about the presumption of compensability. So you've got all your defenses evaluated to the point where you can at least issue a decision. It doesn't mean you're done doing discovery or anything like that. You have to do it within 90 days of the DWC-1 being filed, and that's Honeywell versus WCAB. It is a California Supreme Court case. It's got an exception of when the employer knowingly, knows the applicant suffered it, they mislead the applicant into not filing a claim form, things like that. So in other words, some bad conduct on the part of the employer, that's an exception. If the employer has grounds to object, they got to do it within the 90 days from the DWC-1, and you can't use evidence obtained after the 90-day period if it could have been obtained using reasonable diligence. So you got to be very diligent in that first 90 days because if you don't and you get something later, you could be precluded from using it. There are some exceptions, such as subsequent AME report, or there's fraud by the applicant, and I've had the fraud exam. Actually, I've had the subsequent AME report as well, and credibility evidence. So it's definitely something to think about. One thing that's very interesting is if you've denied it and it's in your claim notes that you've denied it, like actually denied it, and you forgot to send the notice out until after the 90 days, you're still timely, according to the Rodriguez case, because it doesn't have to actually be communicated to the applicant. You don't want to do that because then you got your audit and your penalties and things of that nature. You want to make sure that you, if you deny it, you properly do it as we discussed earlier with your defenses, etc. Denial must be unconditional, meaning you can't say if you don't do A, B, and C, your claim is denied. Absent A, B, and C, your claim is denied. Nothing like that. Your claim is denied because that's what you got to do. These are some exceptions. So I'm just going to leave them here for when a claim is the presumption doesn't apply. These are some examples. I think insurance coverage should also be on there, but I didn't see the case, but I recall seeing it at some point, and it obviously makes sense. It's similar to the employee, but the 6-month rule, good faith personnel action, those psych defenses, it doesn't apply. Statute of limitations, it doesn't apply. All right, so we're going to do a couple practice questions, and then we'll end for today. This is based on a real case. 3 of them, they're all real cases. And this one, it was 100 days after the date of injury and first report of injury that the claim was denied, and 95 days after the applicant's first request for treatment and lost time. So both of those are beyond 90 days. But then the DWC-1 was submitted 77 days before the denial. So it was 77 days after the denial, or the DWC-1 was submitted. And was the decision to deny timely? And in this particular case, it was. And this is Elman versus Capstone Logistics. It was found timely because the date that mattered was 77 days after the DWC-1 was submitted. The next one, in this one, the DWC-1 was 78 days after the denial was 78 days after the DWC-1 was provided, but it was 101 days after the application for adjudication was filed. So now we got an application to go as well. And the court said in Salas v. Carter, the denial was still timely because it was 78 days after the DWC-1 was provided. And then the last example is applicant injured on 6/29/92, denial was issued 112 days after the date of injury and 91 days after the claim form filed. Now this one's got a little bit of an exception, and on its face it looks bad. However, it was denied on Monday. So does the fact that the decision date fell on a weekend impact it? It was timely. Barely, because the 90th day to reject fell on a Sunday, so they had till Monday to deny it. And these are all cases. None of this is this is case law. None of these are made up. This is the state of the case law. So tips for claims handling. I'm just going to run through these and then we're done. You definitely want to promptly investigate your claims. Use reasonable diligence. You want to use the date of injury as the start date for your investigation where you can, and that eliminates any argument by the other side that the presumption of compensability applies. Because you want your, if your denial is within 90 days of the date of injury, you're always timely. There's never going to be litigation. So if you can make it within 90 days of the date of injury, that's what I always recommend. Issue detailed denials with your defenses listed. I'm sure many of you have our reference sheet with all the defenses, and if you don't, please put a note in for Diane and I'll mail them to you. If you're using the post-termination injury defense, make sure you get documentation from the employer confirming a termination or layoff. Not a voluntary resignation. That doesn't count when they resign. That does not count. I see the defense being listed quite often when there's a resignation and it shouldn't be listed. So make sure you get from the employer that there was a termination or a layoff, because that'll protect you in the event that your denial turns into a 132A because the applicant attorney says, well, they fired you after you filed this claim, as evidenced by the denial letter. And I've seen it. So definitely be careful doing that. The next one is to continue to investigate and reevaluate your defenses as more information becomes available. And then lastly, keep in mind the file could be audited. Document your file well. And that does it.
Well, that was a lot. Before we get going, because there are a few things I want to go over, but you mentioned a few things that MacroPro provides these services now. You mentioned internet and social media checks. That is something that MacroPro can do for you. Since you're using us for other things, we'd love for you to be able to contact us for that. What's really cool about our report, James, you mentioned about the pharmacies around there. Our report not only does the social media, but we do a background check. Some people don't have a lot of social media out there. So we're getting you background information. We're giving you the information, what color is their car? What do you want to, what do you care what color their car is? Well, you do care if you're sending your investigator out, you want to tell them what make and model it is. And so we'll be able to get that information off of public records and that type of thing. So we give a really robust social media and internet search report. And then we also could do the medical canvassing. And you're exactly right about the pharmacy. That is where to start. I always tell people that let's just do pharmacies, because you're going to learn and get more information. They're also the ones that are most likely to work with us with the medical release form. So that is awesome. So James, a couple people asked on the videos, is that a mock demo or was that based off of a real claim?
It was based off of a real claim, but it was a mock. Hence the claimant in there is an actor.
Yes, exactly. Now, that's the other thing. Who is the actor? Because I'm going to look to see if anybody actually got the right person so that we can get.
His name is Perry Shen. P-A-R-R-Y Shen.
Like Finn, F-I-N?
S-H-E-N.
Shen. Okay.
Shen.
I will check to see, because there were people who were playing along. So I'll make sure
good.
Done as well. And then we did have one question, and the person says, if the application has a DWC1, is the date of the application the first date of the 90 days, or is it 5 days for the mailing? 5 days later.
It's 90 days from receipt of the DWC1. The application doesn't matter.
All right. Now you have it.
So if you received it in the mail today, you have 90 days from today.
Catherine, you're quite welcome. Thank you for the thank you note. We appreciate that very much. Same D, it's really great. So Debbie, we will get you the document that James was talking about. I see you sent me your email. He needs a physical address because it's this beautiful piece of paper that's been laminated and has all the defenses on it. It's a great, great deal. So if you put that in, anybody else that would like that, I'm going to leave my chat open for just a few minutes, and you can put your address in and James will send that. All right, we do have another Macro Pro and Friends coming up later on in the month. It is on medical set-asides. So make sure you check the Macro Pro website. We're updating that all the time. Thank you, James, very much for this presentation. You're always awesome. And we will see all of you at the next Macro Pro and Friends. Bye-bye now.
Bye, everybody.